Mr. Saul, may I say thank you very much. Our authorities situation has been resolved.
I'm grateful, my lady. I can take no credit whatsoever. Those behind me will hear those kind words of appreciation. Thank you.
As far as I can see, that must be true of me as well.
And me.
No doubt it's my bundles now that are out of order because of negligence on my part. I was going to go next, please, to the decision of the House of Lords in Hilton, Barker and Booth.
No, I'm sorry, I didn't. The House of Lords in.
Hilton, Barker and Booth.
Thank
I'm sorry, my lady. It's not just my bundles that aren't working, it's my projector.
No, it was some background noise. So where am I looking?
It is in Bundle 1, Authorities 1, tab 15.
Thank you.
Now, this is a case which considers the position of a fiduciary, in this case again a solicitor, who places themselves in a position of conflict of interest. Now again, as I have before, I'll go straight to the jugular. Now, what I'm going to show you first, what was said in relation to the duty of disclosure. Now, give me 1 moment. We're in the judgment of Lord Scott, and then a short judgment from Lord Scott, then Lord Walker, which is what I'm going to show you. He deals with the duty of the solicitor to his client, as it's put in the judgment at page 446 of the bundle. And he explains at 29 that the relationship between the solicitor and the client is one in which the client reposes trust and confidence. It is a fiduciary relationship. Now, then at 30, over the page, at page 477, I'm showing you the context here. A solicitor's duty of single-minded loyalty to his client's interests and his duty to respect his client's confidence do have their roots in the fiduciary nature of the solicitor-client relationship. Then there's a reference to possible moulding. And then he says, in this case, no such moulding is necessary. So that's like present case. And then we have this. Mr. Hilton, so the claimant, did not expressly plead that BBE was in breach of any fiduciary duty. He did not need to. Since at trial he was not seeking to take the sort of causation point that was raised in Mothew. On this issue of liability, both sides have been content for the case to be dealt with as a claim for breach of contract. But I stress this. However, the content of BB's contractual duties so far as relevant to this case has roots in the parties' relationship of trust and confidence. I'm showing you that because it's highly relevant to what we then come to when the duty of disclosure of the solicitor is referred to. And for fear of giving the game away before we get there, it's described as a contractual duty. But it's because, in this case, it was pleaded as such. But the judge has been very clear at 30 that when you're looking at this, you're looking at it based on, rooted in, fiduciary duties. And so we can pick it up, please, at paragraph 39, page 449. You will see here that His Lordship refers to Moody and Cox. The action for rescission, where the sellers were a solicitor and his managing clerk, trustees of a will trust, selling as such, in addition had acted as solicitor for the purchase. And you can see what's described. At 40, since Hatt and Cox were selling as trustees, they had a duty to their beneficiaries to obtain the best price reasonably obtainable. It was argued that this modified the extent of Hatt's duty as solicitor to Moody as his purchaser client. That argument was rejected. The key passages in the judgments are set out in Sir Andrew Morritt, the Chancellor's judgment in the present case below. It is sufficient to repeat what my cousin Hardy, Master of the Rolls, said. And you'll see from the quote, I'll just pick out a couple of passages. A solicitor who puts himself in that position takes upon himself a grievous responsibility. And then lower down, he ought, before putting himself in that position, to inform the client of his conflicted duties. And then we see either obtain from that client an agreement that he should not perform his full duties of disclosure. So see the reference there to full duties of disclosure. Or say, which would be much better, I cannot accept this business. And we can see at 41 how that's summarised. And there was an argument seeking to distinguish Moody and Cox, which is referred to at 42, on the basis that it was based on presumptions of undue influence. And that was rejected by the House of Lords. With great respect to Sir Andrew Morritt, the Vice-Chancellor, I cannot agree with that analysis. In Moody and Cox owed a purely fiduciary duty to his beneficiaries and a duty to his client, which was, in the way that I have already explained, which was the passage I showed you, both contractual and fiduciary. The content of the contractual duty of full disclosure being rooted in the fiduciary relationship between solicitor and client. In other words, pleaded here as a contractual duty, but really a fiduciary duty. In the present case, BBE, the solicitors, owed that type of duty to both Mr. Bromwich and Mr. Hilton, and they also had a personal financial interest. And then in Moody and Cox, Lord President Hardy, the Marshal of the Rolls, expressly stated that it doesn't turn on undue influence. So that's that position. As I say, the reference to contractual duty is then made clear. It's made clear by Lord Walker that it's rooted in the fiduciary duties and only expressed in that way because of how the case was actually pleaded in that case. So that's supports the submission I make. I'm then going to leap ahead in time, if I may, and consider engine expert tooling. And I tread into the choppy waters of seeking to explain to a member of the Constitution the judgment they were involved in and how it's to be interpreted. And it is tab 36 of the authorities, which, if bundles are intact, will be in volume 4. And I respectfully submit that this case, correctly analysed, supports our position. Now, you'll be familiar, I expect, with the facts. A case involving the non-disclosure by a fiduciary of the quantum of payments which it was receiving, as well as other matters. And I propose to go straight to the section on the legal analysis found in the judgment of Lord Justice Zaccaroli. And I'm in page 1509 of the bundle. Now, paragraph 42, we see the classic reference to the distinguished obligation of the fiduciary in the facets and the reference to Mothew. And then picking up on exchanges I had before with my Lord Justice Newey, you'll see what is said about them not being outright prohibitions in the reference to Bousting. Now, at 43, the issue raised by ground 1 is whether, as the judge found, informed consent narrows the scope of the fiduciary duty, so that in this case it did not extend to a duty to disclose the amount and funding details the Commission received, or whether, as tooling contends, informed consent operates to negative what would otherwise be a breach of duty. Now, this court concluded that the judge's approach was wrong. Now, I would respectfully submit that it follows, based on how that's formulated there, that if the judge was wrong in taking the view that the scope of the duty was narrowed, it follows that it did extend to a duty to disclose the amount and funding details of the Commission received. because the judge was wrong to conclude that it was narrowed. Now, what follows is a discussion about the relationship between contractual and fiduciary duties and the potential moulding of fiduciary duties to fit the contractual relationship. And you will see over the page at 49 a reference to Hilton against Barker, Booth and Eastwood. And then at 50, Lord Justice Zaccaroli explaining that as the court at first instance in the present case found, there's nothing which requires any moulding. And at 51, Lord Justice Zaccaroli refers to the judge's conclusion that the fiduciary duties did not extend to a duty either to advise on the commission. And Lord Justice Zaccaroli goes on to criticise that analysis. And that's what he's saying when he addresses the matter at 52. And my respectful submission is that what's being said here, consistent with what I said earlier when I explained the two formulations which were being presented by the parties to the court in NG, is that the corollary of the conclusion that one shouldn't approach this from the matter of this, from the definition of scope of duty, is that the judge was wrong in narrowing it. And when one looks at the factors that are relied upon at 53, those are matters that, as the judge said, Lord Justice Zaccaroli said at 54, go to questions about informed consent. But they don't limit the scope of the duty. And so we're approaching it today in a slightly different way. The question is whether, when you're not dealing with a moulded or narrowed fiduciary duty, it includes a duty of disclosure. And the premise in NG was that it did. That's the premise of rejecting the judge's analysis. It does include a duty of disclosure, but when one comes to consider all the various factors that NG sought to rely on, better to look at those. They don't go to the existence or indeed compliance with the duty. They go to something else. And we can see that if one reads down to 54. Having referred to the matters on which Mr. Lord NG relied at 53, Lord Justice Zaccaroli says at 54, these are all matters which relate to the extent that tooling was in fact informed, or could have found out about it, consistent with the authorities which I now term. These are more appropriately regarded to relate to the question of whether the fiduciary duty is negative by informed consent. And then this, if, as Mr. Lord was minded to accept, at least on the facts of this case, the level of knowledge and consent required in order to limit the scope of the duty is the same as that required for informed consent to be established, then any case where informed consent is found would be one in which no duty was owed in the first place. Yet none of the authorities suggest that is the case. In other words, the duty does exist, and it's separate from the question of informed consent. And he concludes in this paragraph, or Justice Zaccaroli, if on the other hand a lesser standard is applied when considering the scope of duty, then that would risk unacceptably watering down the strict duty of loyalty, and that's where we get the watering down quote that we've included in the skeleton. And then Lord Justice Zaccaroli refers to this court's decision in Medstead. And you can see what he says at 56. He says, aside possibly from Medstead, there is no authority which supports the approach taken by the judge. 56. In each of these cases, the question was whether the agent's fiduciary duty not to allow its interest and duty to conflict was breached because the agent did not obtain principles of informed consent. There was no suggestion that the scope of the duty was curtailed in any way. And then at 57, Lord Justice Zaccaroli explains that on a careful analysis of the decision in Medstead, which I'll come on to, I'm conscious I've skipped Medstead, but I'm coming back to it. It too provides no support for the judge's conclusion, and we'll see why. The judge refers to unusual circumstances. And he refers at 57 to what the first instance judge found, and then refers to the conclusions of the Court of Appeal. At 58, Lord Justice Longmore, with whom Lord Justice Peter Jackson and Lady Justice Asplin agreed, concluded that the scope of the claimant's fiduciary duty did not extend to informing its clients of the share of the commission. So that's a case of moulding. And you can see that that's how it's interpreted at paragraph 60. Accordingly, the conclusion as to scope of duty in Medstead was a conclusion of fact, based on the nature of the relationship aside from its fiduciary nature between the parties. And again, no suggestion of moulding or narrowing in the present case that's before you. Now, I just wanted to show you briefly 64. I appreciate we're now treading into the judge's and Lord Justice Zaccaroli's analysis of informed consent. But while we're looking at this case, you'll find support for my formulation of what it is that has to be disclosed. I put it as a duty to disclose. It's full knowledge of all the material circumstances and its conjunctive and of the nature and extent of the agent's interests. And then we get Lord Justice Zaccaroli addressing the first instance judge's reasoning. 65 and 66. And there's reliance on the sophistication of the claimant's officers, that they didn't ask further questions, and that the existence of the commission was said to be a known industry practice. And again, just while we're here, 69, the test for materiality is a low one. Whether the information might, not would, have affected the principal's decision. And then the judge explains the materiality of the matters which were not disclosed. And 72, Lord Justice Zaccaroli rejects the approach adopted, or apparently adopted, by the first instance judge, which included basing the conclusion on the fact that the claimant could have asked, and had it done so, would have been informed of the details. And at 73 and 74, at 74 now, more broadly, as Mr. Grant submitted, this approach misunderstands the duties of a fiduciary. My emphasis, in particular, that it is not sufficient in order to obtain the informed consent that they are given some information, leaving them to ask for more. Quoting Dunn in English. For reasons of policy, he must not only put the principal on inquiry. So this is quoting the Marshal of the Royal Sir George Jessel. He must not only put the principal on inquiry, but must give him full information and full disclosures. That's the language of duty. Again.
But this is all on the heading of informed consent.
I appreciate that, my lady. But my lady may well tell me otherwise. But in my estimation, part of the reason one sees it there is because that is how it was argued in NG. Is it a case of moulding? Or do we go to informed consent? And you've seen how I seek to understand the judgment. And so one sees these passages expressed here, found under that heading, because of how the point was argued in this case. but it's certainly the language, I would submit, of duty and duty of disclosure and full disclosure. And you'll see at the end of 76, and I'm not proposing to come back to the same authorities on the subject of informed consent, which is partly why we're looking at these cases now, as I deal with grounds 1 and 2 together. But you can see that at the end of 76, the principles are said to hold good, irrespective of how vulnerable, unsophisticated, or otherwise the principle happens to be. And you'll see also what's said about industry practice at 77. Here, as you know, XY relies heavily on what they say is industry practice in respect of these particular funds. But there's no finding that my clients were familiar with initiators or had read the Ernst & Young technical guide or whatever it may be. I appreciate
MDM had run the Charm Fund.
Yeah, absolutely, my lord.
Did the judge not find that he was fully familiar with the normal structure of a Luxembourg AIF?
He was found to run Luxembourg AIFs, I accept that. But these were private equity funds that MDM was running. And as opposed to these funds here, with their sub-funds and the initiator and the investment advisor, all referred to by the VP Fund Solutions witnesses and set out and explained in the Ernst & Young Technical Industry Guide. We'll no doubt go to the findings in due course. My learned friend relies on these points. But the findings did not go so far as to say that my clients were familiar with all of the intricacies of the way that these particular funds, with these compartments and the involvement of a party like Twinkle, it was put at a level of Mr. de Montezemolo has operated Charm funds. They qualify as Luxembourg AIFs, and my recollection is that's the nub of the finding as to his knowledge, as opposed to all of the information that the judge sets out based on the evidence of the VP witnesses, which you'll have seen in the judgment. Now, you'll be aware, my lady, my lords, that there was an appeal to the Supreme Court in NG, ultimately allowed by consent, but not in respect of these passages. It dealt with the appeal, prospective appeal, dealt with issues of half-secret and fully secret commissions and the test for dishonesty, and that was resolved by consent in the light of the Supreme Court's decision in Hopcroft, which came out before the appeal in NG was listed for hearing. Now, if I may provide you with 2 or 3 further references on the duty of disclosure. And I won't go to these, I will go to one more case if I may, but not these. You will see a reference to the duty of disclosure and requiring disclosure completely and in detail in an older House of Lords decision called Gluckstein and Barnes, from 1900. And for your reference, it is at page 27 of the authorities bundle. Sorry, I don't think that's right. Forgive me. Yes, that's right. Page 27 of the bundle. And you'll see the duty of disclosure being referred to at page 257 of the report, with completely and in detail being at 258 of the report. We've seen reference to Moody and Cox, which is the 1917 case with the judgment of the Master of the Rolls, Lord Cousins Hardy. There also the duty of disclosure was said to extend to everything that is material or may be material to the judgment of the client. For reference, that's page 80 of the report. And we referred to other examples where a duty of disclosure was referred to in our written opening submissions for trial, which are cross-referred to in our skeleton for this appeal. You'll find the written opening submissions or the extract of them. Tab 16 of the supplemental bundle, page 198. And it's the top paragraph on that page. The last case I'll show you is Image View. I was going to take you to Image View on the subject of forfeiture of fees, but because we're dealing with grounds 1 and 2 now, and I was going to show you in passing some passages that support my submissions here. I'll just show this to you. These were added. They may be in the new bundles.
Tab 50, is it?
Thank you. Yes.
Yes.
I'll just deal with this quickly. I'll come back to this case on forfeiture. You'll be familiar, I imagine, with the case in outline. It's the case of the football agent who was receiving, arranged the transfer of the football to the club in exchange for ongoing consideration, and simultaneously was arranged for, at the instance and having been paid by the club to do so, for a work permit for the player. And that was found to amount to a breach of the agent's fiduciary duty, disentitling him to his remuneration from the player. Now, I'm just going to show you a couple of passages which touch on the duty of disclosure. If we pick it up, please, at page 2006 in the bundle. Paragraph 12. Lord Justice Jacob says here, in those days, he's referring to historical cases, the courts were apt to use the word fraud for breach of an agent's fiduciary duty. These days, such use can perhaps inflame matters and detract from the debate. The term used does not matter, it is the breach of duty which does. And he refers then to the judgment of Lord Justice Fry in a case I'll describe as Ansell's case. In my judgment, the conduct of Ansell and so deemed was a fraud. Now, I just address you here on the question of state of mind, which is something that my Lord Justice Newey addressed in the corporate context in Maru. We were invited to consider the state of mind of Mr. Ansell, whether he thought it was wrong. In other words, we were invited to take as the standard for our decision the alleged conscience. I declined to accept any such rule. And you'll see also that fifth paragraph 15. Note also that it did not matter whether or not Ansell thought he was doing wrong.
This is about secret commissions.
It is a case involving breach of fiduciary duty by the taking of a commission of which the principal was not aware. Yes.
It's not very surprising. It doesn't matter whether you're aware that it's wrong.
Well, I would suggest that at 12 and 15, what we take from those is that the question of subjective intent or knowledge falls away in the context of a breach of fiduciary duty. And just finally in this case...
That's such a provocative statement. So suppose a company director believes that it's in the company's interests to do a particular thing. Suppose the board, all of them, think it's in the company's interests to do a particular thing. It's open to the court to say, no, objectively, that was wrong, that was a breach of fiduciary duty. I mean, that just isn't right.
Well, I understand the tension between those two propositions, and I'll show you in a minute, if I may, with the Court's permission, how the Supreme Court sought to resolve that tension in Saxon Woods.
I'm not sure that's even in the bundle, is it? But I did glance at Saxon Woods over lunch. It doesn't say that. That was that was a director going behind the backs of the board.
It was.
It doesn't take away from the general proposition that to establish a breach by a director of his duty to act in the best interest of the company, you look to see what he thought he was doing.
And the Supreme Court said in the corporate context, where we do have the now expressed language in the Act about what he considers in good faith to be in the best interest of the company, the court in Saxon Woods explains that that's therefore the starting point, but it's not the end point of the analysis.
No, it's not the end point, but the trouble is you're jumping from one particular aspect of fiduciary duties to another, and it doesn't quite work this way.
I appreciate, and in the corporate context, we have language, and this is where, when going back over item software over lunch, when one is in the corporate director context, one does see, and Lady Justice Arden effectively elided the duty of loyalty with what was described as the fundamental duty of a corporate director to act in good faith in the way they consider in the best interests of the company. Because in the corporate context, that's effectively what you go to as your touchstone.
But this isn't something special to directors. Fiduciaries aren't suddenly guilty of fiduciary duty for getting something wrong.
No,
if they think they're acting in the interests of their principals. That isn't how it works.
No, I appreciate that, my lord, and I'm just what we have in Saxon Woods is confirmation from the Supreme Court, and I appreciate the facts in that case were, as my lord has described, and the Court of Appeal and the Supreme Court were trenchant in their conclusion that there'd been disloyalty by the director. But there is a bringing back in my submission in Saxon Woods to the application of an objective test. I'm only mentioning these points because of my Lord Justice Newey referring us to his judgment in Maru, where this was considered in the context of item software. It's not a particular. I don't have a particular axe to grind about those points in this case, but I'm just anticipating what it is about item software my Lord was drawing our attention to, and likewise in Maru. Now, I'm just going to finish on image view, if I may, by showing you paragraph 22. What you're looking at in 22 is a quote from the judgment of Lord Justice Scrutton in a case which is introduced in the judgment here at paragraph 20, Rhodes and McAllister. And at 22, and I draw your attention respectfully to the second extract, the law I take to be this, that an agent must not take remuneration from the other side without, and I stress, both disclosure to and consent from his principal.
And you would say that is different from informed consent?
Because it requires the prior disclosure. So again, both are required. And that's consistent with the authorities that I've shown you that refer to the obligation of full disclosure. And there's a good policy reason for it, and forgive me if I'm going over all ground, there's a good policy reason for it, which is to avoid any doubt about what the position is. And avoid principals being left in no man's land, where they're divining things for themselves. And then one gets into potentially very complicated factual debates about whether the information that the principal has derived from some other source is accurate, material, and the risk is, from a policy perspective, that fiduciaries then consider themselves not under an obligation to give full disclosure, and one can end up effectively taking their chances. Now, is that the financial market in which we want fiduciary financial advisors or other fiduciaries to be operating, where there is
just as a risk of getting over ground? So So suppose you have, I don't know what sort of fiduciary, a solicitor, say, who is trying to do his best. He discloses facts A, B, C, D, E. And as it happens, he fails to mention F, which might also be thought material. But the client actually knows all about F. And the client, knowing he also knows about F, says, no, I'm absolutely happy with all this. There's a claim for breach of duty.
Well, that may be better understood there as a narrowing situation if we're in my Lord Justice Popplewell scenario, where the solicitor is aware of the principal's knowledge of that additional fact.
I suppose the solicitor isn't aware of the principal's knowledge. He's overlooked the need to mention F. But as it happens, the client knows F. And so as well as being told A, B, C, D, E, he knows F and says that's absolutely fine.
Now, there are two ways to look at that, it seems to me. One is, no, it is a breach of duty. Sorry. Now, that's my primary case on ground one. We've explained that in the skeleton. You have to disclose everything. And then an alternative way of looking at it is to say there's a duty, it has to be complied with, but there may be a separate defence based on informed consent derived from other sources. So, to use the language of some of the cases, it may negative or it may provide an escape route from liability. It doesn't mean that there hasn't been a breach of duty. There would be a breach of duty, but it provides effectively an independent defence. That's another analytical way of looking at it. Now, I do caution the court against that second option because of the policy concern that one really does risk getting into extremely granular debates on the nature of the informed consent, where it came from, was it accurate, was it not, what did you know, what didn't you know?
Well, surely all you need to decide is whether the information that's required in order to amount to informed consent is in the hands of the principal. You have to ask that, whether the disclosure is made by the fiduciary or whether the disclosure is made by a third party. It's the same question. Why is there any greater difficulty?
Well, the fiduciary is uniquely well placed
Not necessarily.
to make those disclosures.
Not necessarily. If the principal is put on inquiry and acts on being put on inquiry, why should the burden be on the fiduciary?
Well, when I say uniquely well placed, my lord, I respectfully maintain that position because it's the fiduciary by definition who knows everything. It's their conflict. The transaction being put forward is one they are party to, where they know all the material facts and circumstances which might bear on the judgment of the principal. So I would respectfully submit, again, falling on the policy objectives here, that the principal is in the best position to make that disclosure. And when we're looking at the functioning of transparent markets, by definition, where we have fiduciaries, that's our starting point, this analysis.
But as I understood, what you were suggesting was the policy is that fiduciaries need to know where they are and there's scope for uncertainty. Is that, if the position isn't as you suggest?
How does one best resolve that uncertainty?
But that is the policy you're seeking to invoke. If the principal does in fact have all the information, that oughtn't to be sufficient, because the policy is that the fiduciary would be in a position of uncertainty as to whether he's done enough if he hasn't himself disclosed. I'm seeking to just try and paraphrase what I understand to be your argument. Have I got it right or not?
I think, my lord, approximately yes. I mean, my lord, the it's, pinning these things down, I appreciate, and that is the challenge. But in these situations where there is an expectation of transparency, from a policy perspective, the law should be clear. The burden is on the fiduciary to make full disclosure. They are uniquely well placed to do so, generally. And the risk with adopting it approaching it in a different way is that we do end up with principles with doubt over what is sufficient to be put on inquiry and to fill the gap. And whereas complete clarity in the strictness of the rules that apply to fiduciaries is achieved by placing the onus squarely on the fiduciary to make full disclosure of the facts which they know.
And I'd rather expected you to say that the policy applies because the rationale, which is to protect the fiduciary from the human weakness, it is, as I think it was put by Lord Justice James, necessary for the safety of mankind, which may be putting it a bit high, but that is the rationale, and therefore what matters is the position that the fiduciary thinks he's in, not the position that the principal is in fact in. But that's not as I understand it.
I'm not sure, my lord, in practice there's a great deal of daylight between these formulations. Now, the principle, the human temptation, human frailty formulations are there not only for the protection, my lord expressed it as being for the protection of the fiduciary, effectively to protect them from themselves, but also for the protection, crucially, of the principals, because it's they that stand to suffer in the first instance, before one comes to court and proves one's case at trial. It's the principal that's exposed to harm.
Not if they have fully informed consent. That's the difficulty. They're not exposed to harm.
I can see that, but when one is asking oneself, who is the doctrine there to protect?
No.
In my submission, it's both sides, not just the fiduciary who's there to be stands to be protected by these principles, and that's the, as I read it, the ratio in Rukadze.
And can I just take it a stage further, at the risk of trespassing onto things that would be the subject of the later grounds? So take my situation where the solicitor's mentioned A, B, C, D, E, he's overlooked F, but the client knew about F and gave informed consent knowing all A, B, C, D, E, F. You say breach of duty because the solicitor hasn't revealed fact F. What remedies would be available?
Can I think about that one, please, my lord? I'm going to think about the answer to that question, if I may.
Ostensibly rescission.
Well, it's known in the cases, in some of the cases, as the doctrine of abuse of confidence, not breach of confidence, abuse of confidence. And my lord, the cases do say, and I've shown you some of the extracts, including in Matthew, that absent that full and fair presentation by the fiduciary, rescission will be available.
And just taking it by stages, the potential remedies, rescission, but that's not actually in play in this case.
No.
Account of profits, the principal who's given informed consent can get an account of profits from the fiduciary or not?
It's one, I think, for me to reflect on, but
Yeah.
I say that and then I start to answer, so maybe I'll just pause.
Well, the other one just to think about is compensation. The fiduciary can get compensation from the principal or not.
There are separate principles applicable to causation and equitable compensation.
Meaning you can get compensation where fact F hasn't been mentioned.
No, not necessarily. There are independent principles on causation, and this is the effect essentially of Target and Redfern's and the other cases in respect of causation and equitable compensation, as opposed to the remedies of account of profits, which don't have the same causation test. The breach of duty needs to be there needs to be that factual correlation, but there's no but-for causation test. So there are separate principles on causation.
But what is equitable about having to disgorge profits that the other party knew were going to be made and consented should be made?
Well,
I'm only a common lawyer, but that doesn't, at first sight, seem very equitable.
That's why I posit the alternative approach as well. Now, I have my primary case, and we've come prepared to argue these points, of course, having been kindly invited to do so. But our primary case is a duty, it has to be complied with. And as we've seen in several of the authorities, including the last passage from, I think it was Sir George Jessel's, then the Master of the Royals, it's both. It's both. And indeed, if I recall correctly, the way it's expressed in my learned friend skeleton is that the disclosure by the fiduciary is the means by which informed consent is obtained. That's the turn of phrase they use. And so, duty, referred to in many of the authorities, has to be complied with. And that's how you get informed consent. That's how you get to informed consent. And as I say, and I'll just say it one last time, then move on, the risk if you don't have it in that sequence and analytically set out that way is that you end up in a no man's land around informed consent. And how is that derived? And there is a real risk that the fiduciary, under those duties of disclosure, seeks to escape, or that there's a sense that those duties maybe are watered down because I can find informed consent somewhere else. If I don't give full disclosure, I'll say that they knew anyway. And my lord, that does happen. Those cases do come before the courts.
Well,
and it will be
on that basis, they might say this dishonest fiduciary you're anticipating might just say, "Well, I told them."
May well do so.
And your formulation doesn't solve that problem.
Well, that's true. I can't solve all the problems at the moment. But we do say that it's much clearer for all participants if the fiduciary is under a duty to make full disclosure. It's got to be complied with, and that's how you get to informed consent. And it will clear up any residual uncertainty and arguments and fiduciaries seeking to say, take the point on a witness coming forward and just lying to the court. But we can always find extreme cases which disprove the general approach. But it is better for all market participants for that duty to be clear and have to be complied with, rather than to be some debate about whether the principal found out in some other way, which does really risk, in practice, watering down the prior duty. Because the imperative to comply is reduced, because there'll be some other escape route.
But we know from the authorities that there's often room for debate about what is or isn't material. I mean, that's an inherent uncertainty from the fiduciary's point of view, which is baked into the formulation.
I appreciate that, but one approach is to say that there are other uncertainties, so let's not try and shut down the uncertainties we can shut down. My submission is that we should try and reduce the uncertainties that are left. And if there are residual uncertainties, one can't solve all of those problems through this prism. But it's still better, is it not, to clarify what we can clarify on the issues that are before this court.
But the test for what is material is an objective test, is it? It's not a test as to whether the fiduciary appreciates that it is or isn't material.
No, it's what may have operated on the mind of the...
Objectively ascertained by the court in due course. So again, that's not really focusing on something which is an incentive for the fiduciary to do that which he knows or doesn't know he ought to be doing. And that's in the nature of these what have been described as rigid, inflexible, equitable rules. They operate despite the fiduciary not actually appreciating that this is what he ought to be doing.
I'm not sure that's against me as a proposition, in that the fact that there may be a debate about materiality at a later stage is just a different point.
I just because it may cast some light on your submission that the policy behind what we've been describing in the third party situation is so that the fiduciary knows where he is and avoids uncertainty. Well, all I'm suggesting to you is that
there may still be room for arguments
there's uncertainty
elsewhere.
baked into the system anyway.
I understand that, my lord, but I do maintain that the fact that there may be residual arguments about materiality doesn't mean we shouldn't try and at least resolve the problem that's before us.
It might aggravate the A, B, C, D, E, F problem, because the solicitor thinks I need to tell them facts A, B, C, D, E. He thinks I don't need to tell them F, it's not material. Actually, the client knows F, gives consent. The court later says, well, actually, F was material. On your case, there's a breach.
In my primary case, there's breach. On my alternative formulation, there's breach, but there may be an independent defence, which is that you knew anyway.
Yeah.
Now, I've effectively addressed you now on ground one.
Yeah.
I do say there is a duty of disclosure in the circumstances I've described, and it was clearly breached in this case. Now, informed consent this is a potential alternative defence. As you know, our primary case is that informed consent only becomes relevant and can only be given if the duty of disclosure has first been complied with. And that's consistent, we say, with the point that putting the principle on inquiry is not enough. Now, turning to informed consent itself, what is required for informed consent? We've already considered NG, but of course Hopcraft is the last word. And picking this up, please, in Authorities, Volume 4, tab 39. Page 1741. And it's paragraph 211. And here we still, again, see the connection. Maybe we haven't quite moved on. The connection between informed consent and the giving of full disclosure by the principal, by the fiduciary. 211. Well established that the consent which is required in order to avoid the equitable liabilities which flow from the breach of no conflict rule must be fully informed. The burden is on the payer of the commission or its recipient, as the case may be, to prove, and see the language that's used by the Supreme Court last year, to prove that full disclosure was made. That's not the language of the principal finding out through some other means. Which means all material facts, not enough to place an inquiry. And then this. I think I definitely haven't moved on from ground. The leading authority to that effect is done in English. We saw parts of it earlier. Equitable rescission. Plaintiff also sought disgorgement of the defence profit. It was said in defence that the defendant had disclosed the fact that he was to be one of the purchasers. Master of the rolls held. It is not enough for an agent to tell the principal that he's going to have an interest in the purchase. Now, see how close this is to the present case. He must tell him all material facts. He must tell him. Language of duty. Marshal of the Rolls went on to say, it must be a full disclosure of all he knows. All he knows.
Everything material, he knows.
Absolutely. No, but the everything material, but it's that he knows, that the fiduciary knows. Everything material which he knows. So again, the language is the duty on the fiduciary to disclose the relevant matters. Not sufficient for the defence to say he had an interest or to put the principal on inquiry. And that is very closely analogous to the case that is before you. And so making my submissions now on whether informed consent was obtained, they did not, Mr. Megani and XY did not disclose all that they knew. They told us about Mr. Megani's interest as the entrepreneur of the fund, and that he owned the GP. And they told us, with respect, nowhere near the full story. And so here the judge does not apply the correct test, whether it was looking at it through the prism of ground 1 or ground 2. He did not ask himself whether XY had disclosed everything material that it knows. And had the judge done so, the answer with respect would have been straightforward. That XY, which knew everything that Mr. Megani as its CEO knew, did not disclose. And we also have the suggestion that the correct materiality threshold may not have been applied. Because it's a low threshold, as one saw in NG, and I think it's repeated in Hopper. And so not only was the involvement of Twinkle not explained, and the fact that Mr. Megani was profiting through his ownership of Twinkle, so that was an interest in the transaction that was not disclosed.
Pause there. We're focusing on whether these are material, because it's only an obligation to disclose that which is material.
Yes, ma'am.
And so coming back, we touched on this when we were looking at the chart, but why is it material that Twinkle was involved if what was known and was expected was that it would be something which was a creature of Mr. Megani?
Well, what it goes to is the nature and extent of Mr. Megani's interest. Because what we're being told is he owns the GP, and we know that the GP is engaging VP as fund manager and investment manager. And one's entitled to expect that VP is being paid a substantial sum for that task. And it is, on the face of it, being paid a significant sum for that task. We saw that in the chart. But what one doesn't know is that, in fact, Mr. Megani is profiting elsewhere because he owns and controls Twinkle.
But on the judge's findings, that is exactly what was both expected and understood by Mr. Nunez as to the operation of a Luxembourg AIF. I'm sorry to come back to this, but it is at the heart of ground 2. That is what the actual disclosure that was made, including in the memorandum that there would be an investment advisor, that it was a classic Luxembourg structure, that it was Mr. Megani's product, that the expectation would be, and the understanding of Mr. Nunez was, that that would be very much for his benefit financially, and that he would be heavily involved in advising on the products. And that is all, as far as the judge's findings are concerned, what was known and what was disclosed as a result of disclosing that he was behind the fund.
I'm going to come back because I know exactly the paragraphs to which my lord is referring. I will come back to those.
All right.
But we do say when it goes to both the nature and extent of Mr. Megani's interest, because he's profiting through Twinkle, but it also goes to how the fund works. And to borrow from my Lady Justice Asplin's language earlier, I appreciate sort of summarising informally, but that Twinkle's doing the heavy lifting. That makes this a very different fund. And I will come back to the points my Lord Justice Popplewell has raised with me. Because neither Mr. Megani nor Twinkle have any prior experience. and it very significantly narrows the role of the professional asset manager of VP Fund Solutions. Now that has an appreciable impact on what one thinks the fund one's investing in is.
I'm sorry to keep interrupting. I quite understand that you say Twinkle as a corporate vehicle may not have had any relevant prior experience. But I thought the whole point was that this was the particular expertise of Mr. Megani.
Well, he did not. He had no prior experience in managing investment funds. So he was an individual who recommended, as he put it in his evidence, provide strategic consultancy services.
Well, what do you mean by managing? Choosing the investments to be in the fund. He had experience in relation to that, did he not?
Not in connection with a fund of this kind, no. So individual investments that he might recommend to a client. And so you know that there were investments outside of the Skew Base Fund here. Individual instruments that they recommend.
That was the whole basis of the fund. It was that he'd set up the fund to give effect to his expertise in investment in these particular and other products, wasn't it?
Well,
have I misunderstood what the
no? Well, I think
what
that
the
comes
factual
back.
situation
That comes
was.
back to the question of the particular factual findings, which my lord is, I think, referring to,
Yeah.
as to what Mr. Nutso did or did not believe.
Well, not only that, it's findings as to what Mr. Megani's actual position was. He was the man they trusted because he had the expertise in these products.
But we're getting into facts now, and there are a couple more authorities I just want to refer to. But do not forget, with respect, my lord, that Mr. Megani denied throughout the proceedings that he was in control of Twinkle or had any personal involvement.
What is the relevance of that?
So what?
Well, because
the judge didn't accept that, and we've got the judge's findings.
It rather puts into stark perspective the judge's conclusion, which I'm coming to, that Mr. Nutso thought, was told. This is where the authorities are important, because he was never told this. XY do not allege that Mr. Nutso was told that Mr. Megani was running the fund or selecting investments for the fund, or even running the company that selected investments for the fund. That is not XY's case. XY's case is that we were told that Mr. Megani was the entrepreneur behind the fund and owned the general partner.
And that it follows from that, in all the circumstances of what everybody knew about these funds, that he would be choosing the investments, and that is why, on the judge's findings, he didn't ask certain questions. That's why the exchange of emails is to be interpreted as the judge says it was, and so on and so forth. And I quite understand you say he wasn't expressly told that,
well,
but the judge's findings aren't they? I'm sorry.
No, I'm sorry.
No, go on. No, you
It's
know
not
my
just.
point.
I appreciate we're getting into some factual points, but let me just answer it this way. It's not only that he wasn't told. It's that it's the opposite of what XY said at trial was the position.
And that's what I'd like to understand the relevance of.
Right.
I mean, we know on the judge's finding what the truth was. So why does it matter for our purposes now that Mr. Megani said something different?
Now, because I've been given permission to appeal on, amongst other grounds, ground 5, now the 4th live ground, and that's an unfettered permission to appeal.
Meaning you can challenge findings of fact.
Meaning I can challenge a finding of fact in that context, and I seek to do so.
Which finding of fact here you
But
challenging
Mr.
here?
Mr. Nutso knew that XY was behind the scenes running, effectively actively managing.
Ground 5 is causation. Are you saying you're entitled to challenge findings of fact on informed consent?
Well, it's ultimately the same finding.
I have to say I'm astounded, Mr. Sol. That's not how I understood ground 5. And it's not how I've understood your skeleton argument.
I'm sorry, my lady. Well, maybe we'll get there in a moment.
Maybe we will.
And my lady, if you prefer for me to deal with the submission pretty briefly, but it's a submission I make. Perhaps, my lady, I can put it like this: It's a submission I make in response to arguments made by XY in its skeleton, where they say it's not just about what you were told by XY, it's about what you knew anyway. They say, they make that point in their saying one can well understand why. And so in answer to that, I say, well, I say two things. One, it has to come from XY.
Yeah. First of which you say, yeah.
It's a point of principle. And then I appreciate on informed consent, the court has not allowed me to challenge. On informed consent, grounds 1 and 2, I'm not allowed to challenge the finding expressly by the order of my Lord Justice Popplewell, the finding that we were told that he was a general partner and entry over him. My Lord may recall there was a third strand to ground 1 where we sort of challenged the conclusion that we had even been told that much. In the context of my responsive arguments to XY's reliance, in response to XY's reliance on what Mr. Nutso knew effectively from other sources or had worked out for himself, I raise the point because it's squarely relevant to causation as well. In this way, the court took the view at first instance that because of, and the judge expressed it this way, because of Mr. Nutso and the appellant knowing what they already knew, the causation argument fails. And so in that context, now be totally transparent about it. In that context, I've got permission to appeal. I've come prepared to argue that point, but it's the same factual issue.
Even with ground 5, have you got permission to challenge findings of fact as to what people knew?
And I think both parties have come to court on the basis, not trying to do anything that the court's not comfortable with. On that ground, it was not narrowed. And both parties have come to court on the basis that we are, because certainly XY's skeleton says we seek to challenge a number of findings of fact, they're unassailable. It's not that we're not allowed to go there. It's that applying the relevant test in Volpe, we should fail in doing so. But I have the prior analytical point, which is that if it doesn't come from XY, it doesn't.
And that's
it doesn't
1.
persist.
Yes.
Now this is emerged because my Lord Justice Popplewell understandably has been challenging me, understand entirely why, about what we say about those conclusions. And so I have two answers. One is it wasn't information supplied by XY. And then challenge the factual point. But I'll come on to it, and the points come together because I want the court to be satisfied that these findings about what Mr. Nutso knew were not based on a case by XY, that it had made those disclosures. And that's why it plugs into ground 1.
I'm trying to go back to ground 1, but does it follow from your submission that if information is disclosed, which, because of the particular experience and expertise known to all parties that an individual has, will be interpreted in a particular way, but that experience and expertise doesn't, of course, come from the other party? Are you saying that that means you have to ignore that?
No, my lord. No.
So the information that can amount to informed consent can be a combination of that which is disclosed and that which is available to the principal from their previous experience, their dealings with other people.
If the disclosure is sufficient as to lead naturally to those conclusions.
I mean, if the disclosure is, I'm an independent financial advisor, say, and that's given the nature of the parties, everybody knows what that means and what it usually involves, and so on and so forth. There's no obligation, and therefore the aspects of that role. That's all that's actually vouchsafed, but the aspects of that role, which are the material aspects, are that which the principal knows and understands because of the principal's experience in the past with other financial advisors, experience and so on, then that's sufficient disclosure, even though actually the particular disclosure that matters hasn't come, on your case, hasn't come from the fiduciary. It's the consequences
Well, if it's
of
clearly
the disclosure that's been given.
I suspect, my lord, it's fact and degree here. It will, and one doesn't know. I hesitate to give a blanket response because there's a whole range of cases that could fall into this corridor.
Well, quite, which is why.
But if it's very clear what was being disclosed means X, then that may be sufficient. If the disclosure is a little bit more opaque or open-ended, then it may not be sufficient. Yeah. If we're in the former category and it's clear, I'm saying X, we all know what that means. Then there's been compliance with the duty of disclosure, but not otherwise.
That's really the case against you in this case. It might at first sight look as though not very much is being communicated by saying, well, I'm behind the fund. But actually, in the context of what everybody knew about the funds, that carried with it a whole lot of other disclosures, essentially.
Well, and we say...
And that's what the judge has found, isn't it?
Well, I'm not sure that's quite right.
Right.
Because there is a line between what XY say they disclosed and what the judge found Mr. Nutso believed. And he did not, the conclusion of the judge, at least as I read it, was not by reason of what Mr. Nutso was told by XY, he drew all these conclusions. The judge has relied on a couple of emails, not seeking to be dismissive, a small number of emails, and has then gone on to say that Mr. Nutso must have believed X, Y, and Z. And I'll come on to it in a moment. Appreciate the delicate nature of approaching factual matters in this forum. I understand. But it's difficult it's very difficult to reconcile. One can't draw the link in the way that my Lord's example suggests, in circumstances where XY was itself saying that's not the position. XY's evidence at trial was it rendered no services to the fund.
That wasn't true.
No, well, I think
That's true.
I think they maintain it's true.
Well,
That's the number. But let me move on, and then if we can come back to this. Now, a couple of last cases, and then I'll try and close. Just dealing with some points taken against me now, and we've traversed some of them already. Let me try and cover the remaining ground. And I'll just give you some references. First, paragraph 31 of their skeleton. The respondent seeks to rely on two cases, Coleman and Heavy Industries. Those were cases where what had not been disclosed was the amounts paid to the fiduciary by the other party. And we respectfully submit those are very different cases, because the range of matters not disclosed in this case extended well beyond that. It's the circumstances and manner in which the fund operates, when Mr. Megani has got an interest in the investment being made. There has to be disclosure of exactly how this fund operates. And we can't be left to assume that the fund manager is effectively doing all of the fund manager work and not subcontracting. And the nature of the conflict itself is not fully disclosed, namely that Mr. Megani is also drawing profit from the ownership and control of the investment, which was receiving the lion's share of the remuneration which, on the face of it, was being paid to the external fund manager. And so you have a narrowed fund manager role. And as I say, that has two consequences. Mr. Megani is profiting through another route, which is not disclosed, and the fund is not what it appears to be as an investment. Both highly material. And we don't have disclosure either of the other entities, Leader Logic, which came in later. Next, the respondent relies on Medstead. I appreciate that's another decision that's well known to this court. Now, I've already explained when dealing with NG why that we say that case does not assist the respondents. May I address you on it briefly a little bit further? It's a case obviously the subject of a number of judgments, including one of this court, to which my lady contributed. And that dealt with an appeal from a first instance judgment of Mr. Justice Tier. And I'll just provide some paragraph references to the judgments at first instance in the Court of Appeal as I deal with this. Because when you actually, in my submission, understand Medstead, you realise why it does not assist the respondent. Now, the case arose through the business of a gentleman called Mr. Valasakis. And through his company, Medstead, he introduced wealthy Greek citizens to an entity called Collins Stewart, which was a regulated investment institution based in the Channel Islands, and which provided contracts for differences as what is known as a second-tier provider. And under the rules at the time, individuals wishing to trade contracts for differences had to deal with such a regulated second-tier provider. Couldn't deal directly with the first-tier. In the background, you'll find in the first instance judgment of paragraphs 1 and 2 and 28, and this court's judgment of paragraphs 1 to 6. Now, the way that the arrangement worked was that Collins Stewart would charge each investor a commission. Collins Stewart charges the investor a commission, and it was paying a proportion of that to Medstead as introducer of the clients. It was also a case where the investor clients were described as experienced by Mr. Justice Tier. Now, crucially, the structure I have described was clearly understood by all participants. So the investors knew what product they were buying, through whom they were trading, i.e. Collins Stewart, the total charges being charged, and that Medstead as introducer was being remunerated. It is right that they did not know the precise split of the commission between Collins Stewart and Medstead, but crucially they knew exactly how the transaction was otherwise going to work and who the participants were. The nature of the transaction was clear. What then happened is that the investors and the dealer, Collins Stewart, tried to cut Medstead as introducer out. The investors opened new trading accounts with Collins Stewart in the name of corporate entities, so that Medstead, the introducer, would not be aware. Lies were told to cover that up, and that's in the first instance judgment at 46 to 55, and the Court of Appeal judgment at 1680. And so in these circumstances, upon discovering what had happened, Medstead claims for the share of the commission of which it had been deprived. And what, at first instance, although Medstead proved all other elements of its cause of action, Mr. Justice Tier granted only nominal damages. Why? Because in his view, the relationship between Medstead and the clients, the investors, was fiduciary in nature, and Medstead had not explained precisely how the commission would be split, effectively disentitling it to relief in the eyes of the judge. It might be said, with all due respect to Mr. Justice Tier, now obviously judge of this court, that might be a surprising conclusion given everything else that had gone before, and the established wrongdoing of the investors. Now, the Court of Appeal reversed that conclusion, and Lord Justice Longmore concluded, as Lord Justice Zaccaroli explained in NG, on the facts of the case in Medstead, the fiduciary duty was narrowed or moulded, and did not require disclosure of the exact amount received by Medstead. Clients knew that Medstead was being remunerated for its role as introducer, and the only unknown was the precise split as between it and Collins Stewart. No, there is in this case, as Justice Jacobs has confirmed, no moulding or narrowing. And of course in Medstead, there was full transparency in respect of the nature of the transaction, what the clients are investing in. In the present case, it's not just a question of how much the general partner is ultimately retaining, it's also about what else is going on. We're not told anything about Twinkle's role, that it's receiving 80% of the fund manager's fees for that role, what that meant for the more limited scope of the fund manager's role, and indeed that Mr. Megani owned and controlled Twinkle. So in Medstead, the clients understood the structure, and that's not the case here. My Lord, the next point, engaging now with, I think what my Lord Justice Popplewell has been raising with me, is that the respondents rely on the judge's finding, paragraph 749 and 752 of the judgment, as to what Mr. Nutso knew. So this is Core Bundle, tab 5, Core Bundle Volume 1. Page 229 of the bundle. And as I say, and again, I'm, or at least I like to think I'm sensitive to my Lady Justice Asplin's observation about being surprised at the point I raise here. I understand that, and so, but I'm addressing here a point taken against me by XY in the skeleton. And
yes, I mean, I think if you're going to seek to persuade us, and this better be tomorrow, that it's open to you to challenge the judge's finding of fact, you're going to have to expand on that. And I mean, show us where, for example, it's to be found in a skeleton, even if it's not in a ground of appeal on its face.
Very well, my lord. I understand. Let me address it in this way then. So what you see at 749 onwards are the judge's conclusions about what Mr. Nutso believed. And we can see it about a third of the way down 749. The expression connotes that as Mr. Nutso saw it, XY was concerned with the active management of the fund itself, and in particular the investments that the fund was making. In fact, this was a perception that was very close to the true position. In fact, it was not XY but rather Twinkle, and so on. And at 750, the judge addresses Mr. Nutso's perception. And at 751 again. Now, the starting point is, it is not XY's case that XY ever communicated these things to Mr. Nutso. XY does not allege that it disclosed that it was involved in running the fund. Nor does XY allege that it disclosed Twinkle's involvement in running the fund. And so the judge has concluded, and it's there before you, that Mr. Nutso has worked this out. But I stress the high water mark of XY's case at trial on appeal is that Mr. Megani disclosed that he was the entrepreneur behind the fund and named the general partner. And in addition, of course, as you know, it's our case that he told us about VP Fund Solutions' role as fund manager. And so my submission is, this can't be relied upon for informed consent, because the duty of disclosure is on the fiduciary. And so if the judge took this into account, he applied the wrong test. And my lords, my lady, leaving the principal to guess or join the dots or work things out for themselves and end up with, as you see here, inaccurate conclusions does not count, consistent with it not being enough to be placed on inquiry.
I hesitate to rise. I thought my learned friend accepted a moment ago in response to questions from the bench that under grounds 1 and 2 there is patently no permissible challenge to the judge's findings of fact, not least because that's what Lord Justice Popplewell expressly said when he gave permission to appeal.
I didn't understand him myself to be making that concession, but he's heard what the court has said, and I think was possibly reserving the opportunity to come back tomorrow and have another go at that. I may have misunderstood him.
No, I'm at the moment. I'm not trying to attack the findings of fact. I'm very clear on what my Lord Justice Newey has said about not today.
I mean, but what you've said so far goes back to ground one.
That's what I'm seeking to address here.
Yes.
Now, if one turns up paragraph 12, let me just make sure I'm giving you the right If one turns up the judge's conclusion on informed consent at 12:55, page 363 of the bundle. The judge says, he refers to this being a case of professional investors and MDM running his own Luxembourg fund. Mr. Nutso acknowledged the important role the partner
I'm
plays.
sorry, I'm lost where you're
I'm sorry,
from.
my lady.
No, it's my fault. Not me.
Page 363 of the
Yes,
bundle.
paragraph.
12:55.
Thank you. And you were reading from.
I'm reading from the end of the third line down.
Thank you. I have concluded.
Yes, and then it goes on, I am concerned here.
Mhm.
And the way it's expressed by the judge here, the disclosure that was, I'm a little bit further on now, the disclosure that was made would have made it obvious that Mr. Megani, as the entrepreneur behind the fund, has significant financial interest in its success. The offering memorandum set out the fees that were to be paid. And the judge puts it this way, I do not consider that the absence of disclosure of other matters, for example, exactly how much money was being paid to each actual potential service provider, or how any profits made by the general partner would reach, means that there was not a sufficient disclosure of material facts. Now, it's not clear here whether the judge is or is not relying on the findings he makes at 749 to 751. It's possible that he may have done, because he appears to boil down what was not disclosed to simply not knowing how much money is being paid to different service providers. Now, we've explained why the non-disclosure is much more significant than that, going to the nature and extent of Mr. Megani's conflict and the nature of the fund in which we're being encouraged to invest. And I say that if the judge did take into account the findings at 749 to 751, he was wrong in law to do so, because it is for the fiduciary to disclose the position. Now, I understand, and now I'm not trying to challenge the findings of fact, but I just want you to understand that XY's position was that it had no involvement in the running of the fund. That was the evidence it gave at trial. And I'm engaging here with the conceptual point, which is what if you work it out for yourself? Now, what Mr. Nutso has worked out for himself is not accurate, because XY, and you've heard it from my learned friend, did not supply on its case any services to the fund. XY did not supply any services to the fund, and that was Mr. Megani's evidence at trial. And you've got extracts of the witness statement, and I can provide you with the references. So Mr. Nutso, other than through disclosure from the fiduciary, has reached certain conclusions which, according to XY itself, are materially inaccurate.
But that's why we come back to materiality. XY is one Megani vehicle, Twinkle is another Megani vehicle. Why is it material that it was Twinkle, not XY? What was the information that Mr. Nutso had was, as he understood it, that because of the structure of the fund and because Mr. Megani was behind it, it would be a Megani vehicle who would be expected to be doing the investment advice.
And here we come on to that question of materiality.
Yeah.
And I do submit here that the judge has downplayed significantly the materiality of these points. That the investment advisor is taking 80% of the fund manager's fees, including all of the portfolio management fee and the performance fee. Is that not material to the investor who's being invited to invest in the fund and is being told that there's an external fund manager?
Not on the judge's findings. He said they made no inquiries about that. They made exercised no due diligence into VP. They weren't very interested. And that's because they expected a Megani vehicle to be doing everything. They knew that the gross sum was going to a Megani vehicle as the general partner, and what happened to the money after that wasn't a matter of any concern to them. I mean, those are the findings, aren't they?
I think in summary form, my lord, but we do respectfully say that this doesn't come down to just not knowing exactly how much money was being paid to each actual potential service provider, but it goes significantly further. That is our case. You'll have seen that from the skeleton and the required disclosures. But it does go further than that, and some vague knowledge, which is effectively what the judge found Mr. Nutso had, a sort of broad perception, does not go far enough, but some broad, and I would add inaccurate, perception denied by XY itself at trial and on appeal. It's a very odd outcome whereby the investor reaches some conclusions effectively off their own back, turn out to be wrong, that the advisor, the fiduciary themselves says are not accurate, and yet that's enough to give rise to informed consent. That would be a very, very unusual outcome. I've worked something out for myself. It's not accurate. The fiduciary says it's not the position, but it's informed consent. And just for reference, so you have it, XY's evidence about the lack of any role on the part of the XY group in the Skew Base Fund is found in the unagreed bundle at tab 27, page 115, paragraph 73. A couple of final points, if I may. I'm conscious of time. Firstly, a word about the claimant's sophistication. Much is made of this by XY in its skeleton argument. Now, I would respectfully submit that this is addressed in NG. The duty of disclosure, I submit, is not narrowed because your principal is sophisticated or experienced. And although I didn't go to Lord Justice Snowden's judgment in NG, he also rejected the first instance judge's heavy reliance on the sophistication of expert tooling as a reason to conclude that further disclosure was not required. And of course, my Lady Justice Asplin agreed with both prior judgments given in that case. And at 149 of his judgment, Lord Justice Snowden made it clear that it's not enough for the fiduciary to say that the principal could have discovered the position if asked. And we do submit that the fund in which Mr. de Montezemolo was engaged, MDM, being a private equity fund, is different. And therefore, the findings by the judge based on the evidence of the VP witnesses, and indeed the references to the Ernst & Young guide, not allege that we knew those things or that we'd read the guide, And so this sophistication point in my respectful submission does not assist the respondent. The burden on the fiduciary remains to provide a transparent explanation. And I would respectfully suggest that sophistication here goes even the other way. The more sophisticated the client, the more you as financial advisor will know that they want to know how the fund really operates. And in this case, how limited the professional fund manager's role would actually be. Two last points, if I may. I want to show you first a passage from the judgment itself, which in my submission is inconsistent with the judge's own conclusion. I'm in the judgment, page 91 of the bundle. I'm sorry.
In the interest of getting a double-sided version, I've got a version that doesn't come from the bundle. So if you can give me a paragraph number or internal number.
Internal page 20. Internal page 26. Paragraphs 116 to 117.
Yes, thank you very much.
Now, so paragraph 116. The judge is dealing here. We are in the section of the judge's judgment dealing with his view of Mr. Megani as a witness at trial. And the judge is alighting here upon a piece of evidence upon which I cross-examined Mr. Megani at trial. It was a phone call between Mr. Megani and an investor at the time when the fund was collapsing or had collapsed in around April 2020. You can see that at paragraph 116. And at 117, the judge says, what is clear is that Mr. Megani was asked on 2 occasions to explain his relationship with the Skew Base Fund. He asked initially only from the perspective of XY as a group. And then if one reads on, I am not persuaded. So this is a call to with another investor in the fund. I'm not persuaded that this means that Mr. Megani should not have given frank answers to the questions asked. A frank answer to the question would have involved not simply answering by reference to XY, i.e. what XY's relationship with the funds was, which Mr. Megani had said effectively none, but rather referring at least to the relationship which Twinkle had with the Skew Base Fund. And then the judge says later in the call, Giovanni, who was the investor, or on behalf of the investor, asked again, saying he wanted to understand what your direct relationship was with the VP funds. And a little later, I wanted to understand what your relationship was. Again, Mr. Megani asked by reference to XY's position, in other words, no relationship, and omitted any reference to Twinkle or indeed his ownership of the general partner.
How does this help us?
So the point I'm making, my lady, I understand, is that when the judge is considering, in the context of a different investor, what a frank disclosure would have been, it includes, in terms, in the judge's words, at least disclosing the relationship which Twinkle had with the Skew Base Fund.
This is after the event. This isn't disclosure for the purposes of taking on the client. Right?
Absolutely, my lord.
This is in the wake of the COVID collapse.
I'm making a forensic point.
And
No, I understand that. But the point is, it wasn't for my client to ask. This investor had asked the question, but the point of the fiduciary principle relationship and disclosure, it's not for my client to ask. And when the judge is looking at it in the context of another investor, post-collapse, the judge's view is you should have been told at least about Twinkle. But when it comes to my clients, that doesn't feature. And can I close then, finally, by saying yes, if the disclosures made in this case are sufficient to discharge the fiduciary's duty to disclose, and or sufficient to obtain informed consent, that risks opening the door in particular in the financial markets context, but also other commercial contexts, where the courts will be familiar with the sort of complex structures that can be used. It opens the door to opaque and undisclosed structures and partial disclosures, and a lack of transparency to the detriment of principals. And that would be highly unsatisfactory and represent real inroads to the transparency hitherto expected of fiduciaries. My lords, my lady.
I think you've done well to keep within a time consistent with dealing with grounds 4 and 5 later.
Unless I can assist the court further.
Thank you. Mr. Clarity.
May it please the court. In terms of roadmap for my submissions, I'd like first to look at the relevant background facts as found by the judge in the judgment. I know, from your, not least from your interventions today, that you are all very familiar with it, but I do want to explain the critical findings from the judgment. And I'm only going to look at the judgment. I'm not going to look at extraneous material such as underlying emails and all the rest of it. The reason I'm going to do that is because, as you will have gathered, our position in essence is that once you understand the full findings made by the judge, which are either misstated or ignored in my learned friend's case, it's apparent that the claim fails, whether you analyse it under ground 1 as a question of scope of the duty, or under ground 2 as a question of informed consent. So that's my first heading. My second will be to address some general principles, in particular craft, which is really the critical authority now in this field. Then thirdly, I'll look at ground 1. So I'll show why my learned friend's point about there being a separate prescriptive positive duty is just inconsistent with the authorities. And in any case, even if one looks at it as a question of the scope of the duty, then what was disclosed in this case was sufficient. Or to put it another way, if you're going to discern particular positive duties of disclosure, then you should only find that the things that were disclosed were the critical things to be disclosed. That's why, obviously, I say this distinction between ground 1 and ground 2 is academic. And then finally, I will come to ground 2, an informed consent. As you'll have picked up from the skeleton, my principal point there is that the question of whether informed consent has been given, being a question of fact in all the circumstances of the case, is obviously not one that this court should be interfering with, or shouldn't be interfering lightly. To put that another way, in order to interfere at all, my friend really has to show that there's some irrationality, or that the judge has left some important factor out of account, etc., etc. In any event, we will say under that ground that the judge's conclusions, more than his earlier factual conclusions, more than support his evaluative decision that there was, in this case, informed consent anyway. So, first heading, background facts, and just to stand back for a moment, I've told you that we say that the fallacy in this appeal is to overlook the full extent of the factual findings, and this is not just a question of my learned friend downplaying the extent or the implications of the judge's finding that Mr. Megani owned the general partner and that the general partner received all the fees about which complaints were made and thereafter had control of them. That downplaying is important, and I will address it. But equally, if not more importantly, for the way in which my own friend now puts the appeal, the critical problem here is that the appellants almost completely ignore the judge's important findings about what they were told and what they knew about Mr. Megani and his company's conception and setting up of, and close involvement in the operation of the fund. That's what the judge described in shorthand, and we'll see this when we come to look at the findings, as Mr. Megani being behind the fund. So, more particularly, that involves all of his findings about the appellant's understanding that Mr. Megani and one of his corporate entities were the initiator of the fund, and that therefore Mr. Megani and his company would have a significant role in the investment strategy of the fund. That is, as the judge found, the whole point from the appellant's perspective of going into this fund in the first place. They were doing these trades, dozens and dozens and dozens of them, individually with Mr. Megani and XY in the period before they go into the fund. And all that happens when they go into the fund really is that it becomes administratively much more convenient, because when they increase the amount they're putting into this side of things as a consequence of the new liquidity, as it was put below my friend this morning, it was going to be administratively much more convenient, because the fund would do it all. All you would do is take units in the fund and not have to worry about, as Mr. Nutso had down to that point, on a sort of weekly basis, having to get involved with XY in selecting which market insurance note or reverse convertible or whatever it was that they would invest in. So there was that efficiency. And then there's also the attraction of leverage, which we didn't hear about this morning, but obviously one of the upsides for the appellants in going into the fund was that the fund could borrow money, and if the fund borrowed money rather than them, the fund lost the money. It was only the fund that had to worry about dealing with the banks, because what happened before, the appellants being great fans of Lombard credit, was that the appellants would use Lombard credit, that is, using their various assets effectively by way of security for borrowing from the bank, which they would then invest in more exotic investments. And obviously, when they were doing all that in their own names, they had a direct liability to the banks. And so one of the advantages of the fund is that the fund just deals with all of the leverage. There's no personal liability, you just buy shares in the fund and you don't have to worry about it. But that was the whole point of this. And the whole point of it was not that VP, of whom the appellants had never heard, and of whom the appellants had not a single interaction, certainly no substantive interaction, prior to or during the operation of the fund. The whole point, as the judge put it, was that they liked the man, Mr. Megani, they liked the strategy, his strategy, and they wanted to do that with his fund. So the notion that the appellants were in any material sense unaware that a Megani-owned entity would be very closely involved in the investment strategy is, with respect, absurd. They certainly didn't think VP were going to be doing it, because it wasn't VP that they had the long history of doing precisely this kind of trade with. It was Mr. Megani. And in consequence of that, knowing that Mr. Megani or his company was the initiator, and it was their fund, it was their product, that they also knew that he would ultimately receive the lion's share of the fees. Again, that was the whole point. They obviously know that the general partner takes 100% of the fees that are paid. And then what the general partner does thereafter is actually entirely at the general partner's discretion. The offering memorandum sets out that it will have to pay off the service providers. Well, one of the service providers is VP in the appellant's conception. VP wasn't looked upon, as my friend said, as the real runner of the fund or the investment. It was a service provider, and it was there mostly for technical reasons under Luxembourg AIF or reserved AIF regulations. You have to have a VP, and if you have a VP, they have to do the things that VP did. But, of course, as we'll see in a moment, the appellants appreciated that. Certainly, Mr. Matteo de Montezemolo did, MDM, because he was the CEO of, he'd set up a Luxembourg alternative investment fund. And so I say, before I get into the detail of the judgment, once you understand all that, in my respectful submission, grounds 1 and 2 just fall away, because it's clear that the what my learned friend calls in paragraph 27 of his skeleton the required disclosures, it's clear that those matters were disclosed or were sufficiently disclosed. And it's worth perhaps just reminding ourselves of paragraph 27 of my learned friend's skeleton, because, as it were, my target in this appeal is basically that, the crux of my learned friend's position. If you're looking at this in the core bundle, it's tab 13 of the core bundle at page 444, paragraph 27 of the skeleton. So, 1, the amount and or proportion of fees the companies owned and controlled by Mr. Megani would receive. Well, I mean, that was, I just don't understand sub 1, that clearly was disclosed. It was the whole lot. And thereafter the general partner would pay off the service providers and keep the rest. Secondly, the closely related issue of the role of Twinkle, which was receiving substantial fees, ... Twinkle was closely involved in the selection of investments. Well, with respect, of course, that was, as the judge explained at some considerable length, the whole point. I mean, ironically, they would have had much more of a complaint if it were otherwise, because the whole thing they were buying was Mr. Megani. And then number 3 is the fact that Twinkle was owned and controlled by Mr. Megani. Well, patently they knew that whichever entity was the initiator, and therefore the investment advisor, was controlled by Mr. Megani. As I've said, that was the whole point. So as I understand sub 3, it's really a semantic point. And we saw that in my own friend's discussion of paragraphs 749 to 751 of the judgment, which I'll come back to in a moment. My own friend said, they thought it was XY, also owned by Mr. Megani, but in fact it was Twinkle. So really, in my submission, sub 3 is just a semantic point. But there is no material point here. The point being both Twinkle and XY are owned by Mr. Megani. Now, my learned friend has explained the background to the case and the claim this morning. The appellants invested about 102 million euros in the fund into various different compartments. So, what we're concerned with on this appeal is not the full extent of their investments in the fund. In particular, I think about 25% of that 102 million euros was invested in tangible credit and real estate compartments of the fund. And they don't moan about those. They don't say it was an outrageous deceit that those investments were entered into, because those investments performed brilliantly over time and they made a lot of money from them. It was the COVID crash which impacted on the underlying basket of securities in the relevant compartments, the MIN and HFPO compartments, that on any colloquial use of the word caused the loss that the appellants complained about. So they just restrict their claim to certain compartments of the fund. And, you know, that loss was very unfortunate. Obviously, Mr. Megani was and is obviously sad about that, not just because he was the person behind the fund, incidentally, but he also lost money of his own that he'd invested in the same compartments as the appellants. So when the crash happened with the pandemic, he lost some millions of euros that he'd invested in the fund through Twinkle himself. Now, so far as the English claim was concerned, you may have picked up that there was a sort of campaign of litigation on various fronts, including criminal proceedings in Switzerland, which we don't hear about anymore because Mr. Megani was very recently acquitted on all of the remaining counts. So far as the English claim was concerned, there was this sort of array of causes of action, but there were really three planks to the case. The first was the investment side of things. So this was the claim that XY and others had fraudulently deceived the claimants about the risks of investing in the fund. Comprehensively dismissed. There was the independence claims, which were the allegations that XY had fraudulently concealed Mr. Megani's connection to the fund. And then, of course, there was the conspiracy claim that all of the various defendants had engaged in a conspiracy to defraud the claimants on an epic scale. Now, the conspiracy part of the claim was parasitic on the first two planks, the investment claims and the independence claims, because the alleged unlawful means that were relied on for the conspiracy were those 2 planks, including the breach of fiduciary duty allegation. But the logic, if you just step back and think about it, the logic of the appellant's case drove them to pursue that huge, wide-ranging conspiracy case. The judge obviously adverts to this in the judgment because, as a matter of logic, their fraud claim, or the alleged fraud, just couldn't have worked unless all of these other independent professionals like VP were in on it. And basically what happened, as the judge discusses in paragraph 106 of the judgment, is that the claim was reverse engineered. It started with that's core bundle tab 5, page 89. And it's the final sentence. And obviously the sort of apotheosis of that reverse engineering was the fact that, as you will also have picked up, that MDM and LDM manufactured and pursued well into the trial allegations or claims of fraud against, for example, Mr. Palaschini, which were patently unsustainable, and indeed which they abandoned at trial. Although that wasn't the only indicator, the judge also talks about, as you'd have seen, the fact that they abandoned, in closing, they abandoned the suggestion that various senior members of the VP team were involved in the conspiracy. And as the judge said, well, once you start knocking out all the conspirators, it rather shakes one's faith in the allegation of the conspiracy. Now, the focus of this appeal is obviously on what we all call the independence claims, the alleged deception about the connection. But that's not to say that the judge's findings on the investment claims are irrelevant. They will be particularly relevant when you come to grounds 4 and 5 at some point tomorrow. You'll be pleased to hear that my old friend Mr. Fenimore is going to deal with those to give you a change in presentation. But if we just focus in on the independence claims, and in particular on the fiduciary duty aspects, although as the judge says in the judgment, you can't really divorce their case on fraudulent deception from fiduciary duty, because the way that the appellants put it at trial was that they were just two sides of the same coin, which is why we see the judge drawing on. That's why the section about fiduciary duty in the judgment is actually relatively short, because he draws on all of the stuff in sections E, F and H in particular, because that's how it was put. But when we're looking at the independence claims, there are two central pillars to the reasoning that I've identified already. The first is the knowledge that Mr. Megani owns the fund and the general partner through Twinkle, and therefore has control of the fees. That's the sort of first pillar. And the second is the appellant's knowledge of Mr. Megani or his company's Twinkle's involvement in, or to coin a phrase, its role in the investment structure and its role advising the formally appointed portfolio manager. That's what the judge described as, in shorthand, as Mr. Megani being behind the fund. And obviously those two pillars reflect the different ways in which Twinkle was relevant to the case. Because firstly, Twinkle is the means by which Mr. Megani owns the general partner and therefore controls 100% of fees that are paid. But secondly, Mr. Megani in human form is the initiator, but the corporate form of the initiator is Twinkle in this case. So Twinkle's relevant in those two ways. And although this is a point that the appellants try to ignore, when the judge uses that shorthand for Mr. Megani being behind the fund, he is referring to those interrelated ideas, but in particular, he's referring to the second point, that Mr. Megani is the person who conceived of, initiates, and then is involved in the fund. And before we come to grind through the relevant bits of the judgment, there is a paradox in the way that the appellants approach this case, because to get the breach of duty claim off the ground, the appellants they have to focus on Dr. Megani, the human being behind it. That's the only way they can get the breach of fiduciary duty off the ground, is that the connection exists through him. So obviously, for initial liability purposes, they focus entirely on the man, the substance, as it were. But then when it comes to the question of considering informed consent, or the scope of the duties, if you want to put it that way, they want to disregard the human being and everything they knew and were doing in that regard. They then suddenly, the substance of things on their case becomes much less important, and one has to focus on things like the name of the particular entity that he was operating through. And that just sort of, in my submission, before we get into the sort of detail of the law, is really the problem with the way that the appellants have framed their appeal. You can't get your prima facie fiduciary duty and breach of fiduciary duty by focusing entirely on substance and then forget about substance when it comes to the question of informed consent. So turning then to the judgment. Two preliminary points. One I know first, I know I have well in mind. And we can pick this up at paragraphs 9 and 10 of the judgment. Is quite how sophisticated these particular claimants were. And that's not just a question of general expertise and sophistication. I mean, obviously, they are about as savvy as you could get as an investor in a general sense. LDM is one of the most famous businessmen and industrialists in Italy. MDM started out life as an investment banker, sits on the board of various banks, runs his own alternative investment funds. But the real point we can pick up at the end of 105 on page 89. Final sentence. Quite remarkably, at the beginning of his cross-examination, albeit this changed as time went on, MDM tried to suggest that he had very little knowledge. He might have been the CEO of Charm, but he knew nothing about AIFs. The judge was impressed, and unsurprisingly, so he patently knew all about them. One of the jolliest moments of the trial was when I casually referred to him promoting his funds. He immediately picked me up and got very cross. He said, "I do not promote the funds. All investments in the funds come through reverse solicitation." Because under the AIF regulation, that is an absolute requirement. So it became very clear that MDM in particular knew all about running AIFs, and that is what the judge finds at paragraph 1200. And it's really 1201 is the sort of summary they both appreciate. What's going on, albeit in the case of MDM, as 1200 makes clear, his knowledge and understanding is really quite detailed. Second overarching point, the judgment also explains at some length that independence was not as critical as the appellants would have had the court believe in their reverse engineered claim. I've addressed that in the skeleton. I should just make a correction, if I may, to the skeleton. In paragraphs 13 and 84 of our skeleton, we have referred to paragraph 1169 of the judgment. You should delete that. That was not a...
Simply delete it, not substitute anything else.
Simply delete
Just
it.
delete it.
That was a bad reference.
And sorry,
But-
the second one was paragraph 80.
84, my lord.
Yes.
I'm sorry about that.
There's more than one reference to 1169 and 84. I assume both have to go, do they?
Yes, my lord.
Yep.
But all the other passages that we refer to there, 1193, 1230 to 1232, 1258, etc., we stand by. And that point is important, not just when you come to consider grounds form 5 on the remedies, although it's very important for that, but it is important in understanding how the trial worked through, how things ended up being put in closing, which I'm going to come to tomorrow now, and therefore why the judge's judgment proceeds in the way that it does. I was going to move on to the first pillar, the sort of knowledge of ownership of the general.
So you're moving on to a new area. Really.
Yeah, and I see the time.
Yes. In which case we'll stop there and start again at 10:30.
At the risk of impertinence, if anyone is minded to do even more reading between now and 10:30 tomorrow, we will be looking a lot at sections E, F for Freddie, and H of the judgment. Those are, you will have discerned, the critical sections for our purposes.
Yeah.
Thank you.
10:30 in the morning.
All right.